We didn't know what we were getting to be fair, realistically. I mean, the odds of our case going to the Supreme Court were almost nil.
You are listening to The Wisdom Project, a podcast produced by the Louis B. Nunn Center for Oral History in the University of Kentucky Libraries. I'm Doug Boyd. On June 26, 2015, the Supreme Court of the United States legalized same-sex marriage. This episode is a story about marriage equality, about same-sex couples being able to legally marry. Not many people know that Kentucky played an important role in bringing marriage equality to the country. The Nunn Center has oral history interviews with several of the players in the case that eventually went to the Supreme Court. These interviews actually come from two different projects. One is a project called Out South, LGBTQ+, Oral History Project. The other project is the Hayburn Initiative.
To be clear, it's the John G. Hayburn II Initiative for Excellence in the Federal Judiciary.
Clearly, now is the time for me to introduce Anu Kasarabada, who is the archivist and oral historian for the Hayburn Initiative. The Nunn Center works very closely with the Hayburn Initiative on the Oral History Project, so Anu and I are going to tell this story together. Why don't you first explain the Hayburn Initiative?
It is a project at the University of Kentucky that documents the federal court system, particularly the judges who preside over that system and the cases that come through it.
So what's the connection between marriage equality and the Hayburn Initiative?
As it turns out, John G. Hayburn II, the person for whom the initiative is named, he was the judge on the marriage equality case that we're going to talk about in this episode. So he'll play an important role in our story.
And this story is about marriage equality, about same-sex couples being able to legally marry. But it's not just about getting married, right?
No, it's about same-sex couples having the same rights, responsibilities, privileges, and social status as straight couples, which, up to 2015, they did not have in Kentucky.
Break that down for me. What does that mean?
Well, in 2004, Kentucky voters approved an amendment to the state constitution saying that the Commonwealth would not recognize marriages between same-sex partners. At that time, Hawaii, Massachusetts, and other states were beginning to legalize same-sex marriages. So with that amendment, if those couples moved to Kentucky or they had dealings in Kentucky, the state did not have to treat them the same as straight couples.
How does this connect to the Supreme Court case?
In 2013, 4 same-sex couples in Kentucky sued the state, arguing that the 2004 amendment was unconstitutional. They took their case, which was named Bork v. Beshear, up to the Supreme Court, along with more than 10 other couples from Ohio, Michigan, and Tennessee. And they won marriage equality for the whole country in 2015.
Okay, there's a lot going on here, so here's what we're going to do. In this episode, we're going to listen to stories from our interviews with plaintiffs and a lawyer in one of the key cases and walk through the Kentucky roots of marriage equality. Anu, let's first introduce the cast.
We have Greg Bork and Michael DeLeon, both of whom were born and raised in Kentucky. They've been together as a couple since 1982 when they met as students at the University of Kentucky. Greg and Michael got married in Canada in 2004, and they eventually settled in Louisville. They also adopted 2 children, but Kentucky didn't recognize that they were married, which jeopardized their legal relationship to their children.
In our first clip, let's hear from Greg Bork.
Well, I would say family was our motivation for filing the lawsuit. We have 2 adopted children. Kentucky's laws do not allow non-married people to jointly adopt children. So when we adopted children in 1999 and 2000, we had to adopt those as single-parent adoptions. So Michael was the adoptive father for our 2 children, but because the Commonwealth of Kentucky did not recognize our legal marriage, they would not allow me to co-adopt the children. So 1999 and 2000, up until 2015 when the ruling was made, I was not recognized legally as a parent for our children. So that was our motivation for filing the lawsuit. We wanted to be able to provide our children with kind of that stability and to know that they have 2 parents. So we wanted our kids, and we wanted other kids in Kentucky and really throughout the whole country who are in similar situations to be able to feel confident that they have legal parents and they have the same rights and protections that other kids have. Our kids didn't have that. So we filed our lawsuit. That really was our justification in our minds when we said, if we're going to do this, this is why we should do it.
Kim and Tamara Franklin were another Kentucky couple who fought for marriage equality, country girls, as they call themselves. When I sat down with them for an interview, they talked about growing up in Simpsonville and how they've known each other since they were kids. They became a couple in 2007 and married in a civil union outside Kentucky several years later, and they have their own reasons for filing the lawsuit.
Here's Kim Franklin.
We were in it for 3 reasons. Medically, to be able to take care of each other, benefits such as insurance and things like that, and life insurance, and the people that came along behind us. It was about those 3 things, and it was about the people that come along behind us, the younger people, so they wouldn't have to go through what we went through.
Anu, I know precedent is important in law, so how did we get to this point?
It starts with Edie Windsor, a woman in New York who fought at the Supreme Court in 2013 in a case called United States versus Windsor. Edie was the widow and executor of her late wife's estate. But federal law, specifically the Defense of Marriage Act, or DOMA, didn't recognize their marriage. So Windsor had to pay hundreds of thousands of dollars in estate and inheritance taxes. So she argued that that was unconstitutional, and she took those arguments up to the Supreme Court. Shannon Faber and Dawn Elliott, 2 attorneys in Louisville, they were paying close attention to Windsor's case. I interviewed Shannon in 2022, and she talked about waiting for that ruling.
So we were sitting here waiting, like we're talking about what's going to happen next, because it depends on how short, it can be a really broad ruling or a really narrow ruling. Mm-hmm. We don't know.
In June 2013, a narrow majority of the Supreme Court held that, that part of DOMA was unconstitutional. Married same-sex couples deserve the same tax benefits as straight couples. And the court pointed out in its opinion, we're not ruling here on whether same-sex marriage itself is constitutional because no one asked us to decide that. That made Shannon's ears perk up.
Every attorney in the country goes, oh, well, there you go. Here we go. So Dawn and I were sitting here having some bourbon and decided to, because this is Kentucky, and so we decided that we were going to file. We're like, this is a conversation. Somebody should file. Yeah, somebody should file. Oh, we should file. Okay. So neither one of us had ever done a civil rights case before. But we both had represented LGBT people for years, so it was not an issue. So.
What does that mean? I guess what I'm asking is, how does one actually go about filing a case like this? Take me back to Schoolhouse Rock.
First, you need people, same-sex couples in this case, who are willing to be named as plaintiffs in a lawsuit to sue the government. Shannon and Dawn...
The attorneys.
Right. The attorneys, they plan to sue Kentucky and argue that in light of the Supreme Court's decision in Windsor, that the state's ban on recognizing same-sex marriages was unconstitutional. Shannon called her clients, also her friends, Kim and Tammy Franklin, to ask if they'd be the plaintiffs on a case she wanted to file suing the Commonwealth. They said yes, and so Franklin versus Bashir was born.
So Kim and Tammy were the first couple in Kentucky to sue for marriage equality?
They were. Shannon files the Franklins' case in the Eastern District Court of Kentucky, which is the federal region for Cropper, where the Franklins lived. But meanwhile, Greg Bork and Michael DeLeon had also reached out to Shannon about filing a lawsuit. They live in Louisville, which is covered by the Western District of Kentucky, so they filed Bork versus Bashir in that federal region.
So there are 2 cases.
For a hot second, yes, there were 2 cases. Here's Kim explaining what happened.
Now we're going to have 2 lawsuits, 2 different sides of the state. If there's a split in the decisions, then it's going to get real complicated. So it was just decided that all things combined, that we would merge the cases. Mm-hmm. So at that point, when our case merged, it technically got dismissed.
Okay, so to recap, there's this attorney in Louisville, Shannon Faber, who's initiating all of these cases. And for simplicity and efficiency, they dismissed Kim and Tammy's case so they could combine cases, which eventually became Bork versus Bashir.
Right. Here's Shannon on that.
We had two couples, well, three in Louisville, the one case in Shelbyville. But at that point, it was all people who had been married in either other states or Canada, but they weren't being recognized in Kentucky. Either for taxes or adoptions, you couldn't adopt your own child, basically, because only one of the parents could be on adoption. I don't know. I mean, I don't know if we knew. We didn't know what we were getting into, to be fair, realistically. I mean, the odds of our case going to the Supreme Court were almost nil. People were filing across the country. Like, I had a chart, like who's filed here, who's that.
Shannon filed Greg and Michael's case in July 2013, and from that point on, there's just lots of briefs, lots of filings at the court for the next 6 months until the judge makes his decision in February 2014.
Wait, so it wasn't like everybody dressing up and showing up for their day in court with like the judge and the gavel and...
No, there was no trial. No one got up on a witness stand. The attorneys didn't make stirring opening and closing arguments. It was briefs filed with the court by the plaintiffs, represented by Shannon, and briefs by the defense, which in this case was Governor Steve Bashir, represented by his attorneys.
Okay, a dumb question. What's a brief?
Really simply, briefs are written legal arguments that each side of a lawsuit submits to the court. These are documents in which each side argues why they're right and the other side is wrong, why the laws or the Constitution is on their side.
Okay, so briefs are going back and forth. Here's Michael describing how this legal wrangling felt to the couples.
Well, I mean, that was a long process, though, and we just, it was like, you meet a milestone and you wait. You meet a milestone and you wait. I think we both learned a lot about our court system because, I had all this stuff in school, but, you just kind of learned it for a test. And so...
And here's Greg reflecting on the personal impact of all that media exposure.
But I can remember reading in those days, the local papers or even the national publications would post an article and readers could comment at will on these articles. And so when we filed our lawsuit, I can remember reading some of the comments that people left, and it was frightening. And Michael will tell you the same thing. And so we got some advice from folks very early on. Don't read the comments. So we stopped doing that. But it was really troubling. I guess we didn't realize how far out there we were and how much we stirred up people on both sides of the issue by going to that level of actually filing a lawsuit.
As Greg says, the media picked up on the case, word spread, and more couples joined the case as plaintiffs. Shannon and Dawn, the lawyers, they decided to ease their load by bringing on another law firm to work on the case with them. But the more attention, more plaintiffs, more attorneys, it all made for a tense situation. As Kim says,
we would have meetings with the plaintiffs, sometimes without the attorneys. And we didn't always agree on who should be the lawyer, who should be the lead lawyer, how should we do it. We always agreed where we wanted to get to. We always agreed that the case was more important than the individuals, be it plaintiffs or attorneys. We always agreed on that. That was not in debate. What we didn't agree on is the best way to get there. But we always agreed that here's where we wanted to get to and that the case was more important than us.
So what I'm hearing is that clearly there's internal tension among the couples and the attorneys.
There is internal tension, but wait, it gets even thornier. Here's Michael.
Right away we figured out, we had one interview which, it was on the phone with somebody from D.C., and then we just looked at each other because we realized it wasn't necessarily a friendly interview. And it was actually an LGBT, story, but it was more of how did you guys just not follow protocol because Kentucky wasn't on the they weren't on the list for the marriage equality roadmap. So we didn't know there was a roadmap. We just You know, and during the interview, we actually joked that we made our own entryway onto the roadmap. So,
Okay, explain what roadmap and what protocol.
Keep listening.
HRC, Freedom to Marry, and ACLU, they kind of were working together, and they had the states mapped out on how they were going to win marriage equality, you know, state by state, whether it was in the courts or through the legislation. You know, that they would win these cases. And, you know, there was a plan. And but we weren't we were one of the first states to kind of just blow up the plan. But, you know, other states, Texas, they weren't on the roadmap, you know, and a lot of the states in the South were not. So.
There was a national legal movement to get the courts to recognize same-sex marriage. You heard Michael name-check several of the biggest players in that movement. ACLU, and HRC, which is the Human Rights Campaign. That movement had a plan, and Kentucky, an overwhelmingly conservative state, especially on cultural issues like marriage, wasn't a part of that plan. At the same time, local legal activists like ACLU of Kentucky and Fairness for All, they weren't happy with the lawsuit either. Here's Shannon describing a call she received from ACLU of Kentucky.
ACLU calls me, and to make a phone conference with us. I figure they're going to help, right? No. And Fairness did the same thing. They told people not to come to us. Now, we've all worked it out. It's all fine now. But they didn't think we could ever win gay marriage before you can't get the right to not get fired in Kentucky. That's what it comes down to. Especially Fairness. They didn't want us to hurt the cause, is what it comes down to. Because they didn't think we would win.
I would not have even considered that. But I guess when you stop to think about it, it makes all the sense in the world. I think what I'm thinking is, why did Shannon think that she could actually pull this off?
Well, here's one reason, or one name, I should say. John G. Hayburn II. Remember, he was the judge on Bork versus Bashir. When Shannon realized that Judge Hayburn was the one who was going to preside over their case, she felt like they had a real fighting chance.
Because, like I said, Judge Hayburn has known for doing what's right and following the law, so it doesn't matter if it was politically whatever, you know, that he would rule on the law. That's actually what it is. He wasn't going to just go, oh, no, this is not, you know, gay people, blah, blah, blah. I didn't think it was, he would think we'd follow the law, and the law says that people are supposed to be treated equally. That's what it comes down to.
Based on what we just heard Shannon say, and I already know the answer to this question, but I'm going to ask it anyway. How did Judge Hayburn rule?
In February 2014, he ruled in favor of Greg and Michael, Kim and Tammy, and the other plaintiff couples. He held that Kentucky's ban on recognizing same-sex marriages violates the United States Constitution. Kentucky law must treat same-sex couples the same as it does straight couples. Here's Kim and Tammy on what the decision meant to them.
That's still, you know, the Hayburn ruling is still, I think, yes, maybe I'm a little bit biased, but I think is one of the better written decisions in the whole process of the case. Just the way he put it out there that, you know, these people have this right. They're not, they just want to live their lives. And I don't remember his exact verbiage, but just basically that the Constitution gives them that right. They don't want to hurt anybody. Their marriage doesn't affect yours, you know, and
it
just...
It doesn't mean it takes away. Every gay marriage doesn't take away from a heterosexual, you know. Mm-hmm. He was extremely supportive, and in his words, he was just really emotional. He put him out there really emotional.
Yeah. So his ruling and his verbiage and the wording was wonderful, I think.
Anu, you are steeped in this case, in its history, and in Judge Hayburn's legacy. What do Kim and Tammy mean when they say that he was emotional in his decision? Well,
Judge Hayburn could have written his decision in a pretty spare style, sticking solely to jargon-laden legalese. He didn't do that. Instead, he wrote so that the public could read and understand his reasoning. He evoked in it the larger story of the struggle for marriage equality in Kentucky.
Can you give me an example?
So, in the opinion, he harks back to 1972 and a lesbian couple in Louisville, Marjorie Jones and Tracy Knight, who sued the county for a marriage license. They were among the first in the country to do such a thing. And Judge Habern says that his decision in Bork can't be understood without first understanding how society has changed since Jones and Knight took such a step back in the early 70s. He goes on to compare Kentucky's treatment of same-sex couples to Jim Crow segregation and how the state also once deprived women of equal rights. Bear with me here, because I want to read you just a couple of lines from his opinion. So he wrote, quote, "In time, even the most strident supporters of these views understood that they could not enforce their particular moral views to the detriment of another's constitutional rights. Here as well, sometime in the not-too-distant future, the same understanding will come to pass." Unquote. These aren't words that you were necessarily going to hear from public officials back then, so it really stood out.
Well, great. So we're done. Case closed. 2014, same-sex marriage is legal in Kentucky, right?
Well, you're partly right, but once again, it's complicated. The Attorney General of Kentucky at that time, Jack Conway.
I think it's important probably to interject, that both the state's Attorney General at the time and the governor were both Democrats.
Absolutely, that's an important point. Attorney General Conway, he's the one who tried the case on behalf of Governor Beshear. He refused to appeal Judge Habern's decision.
I mean, that makes sense, right?
But Governor Steve Beshear disagreed with his Attorney General. And so when Conway declined to appeal, Governor Beshear found someone who would. Here's Kim reflecting on what that felt like for the couples in the case.
But the decision came down, and I remember almost immediately Conway came out and said he would not appeal. And then almost immediately behind that, Steve Beshear came out and said he was getting outside counsel. So we went through these highs and lows. The decision was in our favor. Oh, yeah. And then all of a sudden, well, he's not going to appeal. Yay, he's going to appeal. Yeah. And we would have conversations. What does this mean? What does this mean for us?
Here's more from Shannon.
Honestly, did not think they were going to fight us because of the fact it was a Democrat governor, too. I'm like, and actually I talked to him later after all that stuff. Because I'm like, what are you doing? Why would you not just say okay when the judge ruled for us? So.
And what did he say?
It's a political decision, so they would go to the higher court and to make it, make a decision for everybody. I'm like, okay, I understand that, but it stings when you're my governor, and you're saying that no, my clients don't count, basically.
So, despite the Habern decision, the story was not over.
Correct. The story doesn't end with Judge Habern's decision in 2014. In fact, Kim, Tammy, Greg, Michael, Shannon, they took their cases to the Supreme Court, and they won for everybody in 2015.
But back here in Kentucky, Judge Habern's decision represented a real win for same-sex couples.
Right. A Kentucky judge recognized the rights of LGBT Kentuckians. For Greg and Michael, Kim and Tammy, for Shannon, the lawyer and all this, they were all vindicated in their willingness to put themselves out there with a lawsuit.
For such an important case, it's strange to me that a lot of people, including here in Kentucky, don't really know much about this case or about the people who brought marriage equality to Kentucky and eventually to the nation.
Yeah, and in fact, I just want to note here that we're not even fully telling the full story here in this episode. Greg and Michael, Kim and Tammy, the case they brought to court focused on same-sex couples who married outside Kentucky. But a whole other case called Love versus Beshear involved same-sex couples who married within Kentucky. That lawsuit was brought by Timothy Love and his husband Lawrence, and Maurice Blanchard and his husband Dominic.
you and I have talked about eventually expanding the Oral History Project to document some of these other cases and also the Supreme Court phase.
Right. But you also noted before about how knowledge of the case and the impact of this case are not well known. Well, in their oral history, Kim and Tammy talk about participating in pride parades years after they won at the Supreme Court, how people their age celebrated them for what they did, but that younger generations don't blink an eye about it.
So, like she said, when we were up to this Shelbyville Pride, there were some people that were our age that once they knew who we were, they're more like, oh my God, thank you, and we're so happy, and it's nice to meet you. And then someone younger would just be like, oh, okay, who are you? And some of the older people were upset. And they would be like, how do you all deal with that they don't appreciate what you did? And we said, that's the point.
Yeah.
The point is that it's not a big deal. We are not a big deal to them. It's just normal. So through most of their growing up, part of their life, gay marriage was the thing. It was okay. It was done. It was legal. They don't know any different. So the people like us and older than us and have fought the battles before us, and there's, hundreds and thousands of millions that fought the battle before us to get us to where we were. When we took the fight on, because we didn't wake up one day and say we're going to be marriage equality plaintiffs. It just happened, and we're honored to be a part of that. But the people that were younger than us that came behind us is why we did it, and so that when we are introduced to someone younger that it's not a big deal, we're not a big deal. That's the point.
Yeah.
Mission
That's the
accomplished.
point.
What a great story. Not everyone in this life gets to be so central in such enormous change. Anu, thank you for helping tell this story.
Thank you, Doug. It's always a pleasure to talk about the people involved in this case, and I'm really looking forward to interviewing more of the Kentuckians who fought this fight.
All of the interviews that you heard in this episode are online and searchable at KentuckyOralHistory.org, where you can also find a complete list of all interviews conducted by Anu and the Heyburn Initiative. You can find more information about the Heyburn Initiative at heyburncollections.org. Thanks for listening. Stay tuned for another episode of The Wisdom Project.